Thank you, JTI ครับ so let me start by make sure that interpreter is okay at the moment. So for Thai participant who would like to listen in Thai language, you can use in translation mode, interpretation mode. You can select Thai, no, Thai language. But for a speaker who would like to listen in English or whatever that speaker speak, you can use no need to select anything, just original audio. That means interpretation will be on. And for just Madan local, so you can use original audio, I think. So you can speak in language. But if there is any question, perhaps you can if maybe you switch to English because if there is any participant would like to ask a question in Thai, right? It will translate into English. So are you in original audio mode or in English mode now?
I will speak in English.
Okay, sure. Okay. Let me check with okay, let me start. For this session, I will introduce you in English. Thank you, everyone. Thank you, participants, for joining the second day of the training. It's for knowledge exchange from various countries in digital transformation. So in the second day, it will be a knowledge exchange from just you was responsible and work directly on digital transformation. So they can share experience from that. So yesterday we talked about the concept and also some examples and in many countries, but now we can listen from one who actually work on that or highly related on that issue. For this 9 to 10, we invite our honorable speaker to speak. He was appointed as Additional Solicitor General of India in 1998 and Additional Judge of Delhi High Court in 1999. And during his career, he was appointed as a Judge of Supreme Court in India and retired in 2018. So he was a member and later chairperson of the Mediation and Conciliation Projects Committee of the Supreme Court. He was also the judge in charge of E-Committee of the Supreme Court for the computerization of all the courts in India. He was appointed as one-man committee to suggest improvement in the working of homes and organization under Juvenile Justice Acts and Rule. He was also the executive chairman of Supreme Court Legal Service Committee and later of National Legal Service Authority. He was appointed as Judge of Supreme Court of Fiji in 2019, and only Indian to be appointed in the High Court, in the highest court of another country. Presently, he has a professional chamber practice and is an independent arbitrator. He writes frequently on legal issues of importance. He's interested in I would like to invite, welcome Justice Madan Vimaro Loker to speak.
Thank you. Thank you very much. And good morning to everybody. I would like to speak about the experiences that we in India have had on implementing digital transformation, that is computerization of the courts in India. So I will speak in 3 sections so that there is some clarity on what we have been doing. I think the most important thing that we have realized is that it is absolutely necessary to plan out what is it that you want to do. When you are saying that you want to computerize the courts, it is important to know what exactly do you mean by computerizing the courts. Now, two things are fairly clear in this regard. One is that you will need hardware, that is to say, computers. You will need that. You will need printers. You will need scanners. You will need photocopiers. Uh, that is understood. But what is the hardware? What kind of a computer do you require? I think that is something that has to be seen, because you are looking at the future. You're not looking at the present, because this system is going to be operated for at least a few years. So the hardware requirement is absolutely essential, understanding what is the hardware requirement. The second requirement is that of software. Now, in India, we have something like 19,000 courts. So it is necessary to have a software that is robust enough for use by 19,000 judges. The cost involved in purchasing proprietary software is very, very heavy. For 19,000 licenses, if we have to purchase, it is extremely expensive, and the computerization process would have perhaps come to an end. So what we decided was, and this was the first challenge really, was how do we overlook or tackle the cost issue. What we decided was to go in for free open source software. It's called FOSS, free open source software. Now that is free. We have not had any experience of any virus attacking the software. And therefore, we were able to send this out to all 19,000 judges, plus an equivalent number of staff, because each judge has a staff. So another 19,000 staff. So really this free open source software helped us a lot. Now, developing that free open source software, there are two problems. One problem is that you need experts to develop free open source software. Many people are familiar with proprietary software. It could be Microsoft, it could be Apple, but there are not too many people who can work on free open source software, FOSS. But we were able to get some professionals, and it took a lot of time. It's not something which you can prepare overnight. So it took us almost about 2 years to prepare some outstanding software which could be used by 38,000 people. The second challenge was that of training. How do you train so many people? You need to train the staff. You need to train the judges. We took the assistance of the Judicial Academy. In India, we have about 30 judicial academies in different parts of the country. So we took the assistance of all these judicial academies to do the training. Now, again, it is a very difficult and long process, because we did not have so many experts who could use that software. It was just the beginning. But over a period of time, we developed a system of trainers. We developed a system of master trainers. And through these trainers and master trainers, we were able to reach out to all the judges in the country and to all the staff. I will not say that the training has been perfect. I will not say that everybody has been trained very well, but I will say that at least about 90% of the judges and 90% of the staff have been very well trained, and they know how to use the software that has been provided to them. So this is really the first challenge that all of us will face in implementing digital transformation, and planning therefore is very, very important. The second aspect is that of involving the stakeholders. Who are the persons who are involved in ensuring that the codes are fully computerized? And it is not only that they are computerized, but that they are efficiently computerized. You need, of course, to train the judges. There is no doubt about it, because it is the judges who are going to be using the computers. They have to be familiar with the software. They have to know how to switch off, switch on, do the recording, and so on. So really, we had to train the judges first. Second, we had to train the staff, because in case of some difficulty, the troubleshooting becomes a problem. And unless the staff is fully aware of, what is the software, what is the nature of the hardware that is being used, what are the problem areas, it becomes difficult. And if the code, is unable to function on a computer, it can create its own problems. So we had to train the staff. And like I said, we used the judicial academies in different parts of the country to train the staff and to train the judges. Third, you need to train the lawyers, because the lawyers are going to access the system. How will they access the system if they are not aware of what is to be done? You have something called e-filing, where you have to file not hard copies, but through the computer you file, a petition, an appeal. Now, the lawyers have to be trained for that. They must know that what is the procedure for e-filing? What is it that goes into the process so far as the court is concerned when a document is filed through the e-filing process? So this was really a challenge. And I must say that we have had some difficulty in reaching out to the lawyers for training them, because they are more used to coming to the court and doing the filing, but it is absolutely necessary. As luck would have it, because of the COVID pandemic, many lawyers had to switch to digital filing, e-filing. So in that sense, they had to get themselves trained on their own on how to file digitally. Litigants also need to be trained. Litigants want to know what has happened to their case. Has some order been passed? If the order has been passed, what is the order that has been passed? If the case has been adjourned, why has it been adjourned? So they also need to understand how to access the system. Now, we have made that available. Of course, training litigants is going to be a problem because India is a large country. We have a large number of litigants. But we had prepared videos which we put up on the website of the courts, that in case you want to know how to file, digitally file, how to access information, the videos are available. So we prepared videos in different languages so that they could be accessed by the litigants. Now, taking all this together, we were able to, proceed further and train all the stakeholders or all those persons who want to access the system. We have one very critical stakeholder, and here it is the prosecution or the police, which also needs to be trained, because we have a large number of criminal cases as it is in different parts of the world. And the police want to know, the prosecution wants to know what has happened to their case. So we took the advantage of police academies, police training academies to train the police officers. It was a collaborative and a cooperative effort because we as judges did not know anything about cyber crimes. When you have a cyber crime before you as a judge, how do you deal with it? How can you be sure that the evidence that is placed before you is genuine evidence? It has come from a computer source. So this became a bit of a challenge. So we had a tie-up with the judicial academies that we will train their officers, and their officers who are experts in cyber crimes or dealing with cyber crimes, extracting data from a computer and so on, they will train our judges on how to deal with cyber crimes. So you have a very large number of cyber crimes. Stalking is one of them, hacking is one of them. There are far more serious crimes that are being committed by these cyber criminals. So really, it became a collaborative effort, and we were able to get the police to assist us, and we assisted the police in the training process. So really, through these methods, we were able to overcome the challenges that we had, namely that of training the various stakeholders, that is judges, court staff, lawyers, litigants, the police. Now, in India, we have a large bureaucracy, as you have in every country. Many of these bureaucrats go to at the administrative training institutes. So we had a tie-up with these administrative training institutes, not for the purpose of training the bureaucrats, but to familiarize them with the computer systems that we have in the courts, so that the bureaucrats, if they want, they can attend a course and perhaps access the information that we have. So this is the way we overcame some of these challenges that we had. Then the third thing that I would like to emphasize is that computerizing the courts is actually a full-time assignment, because you are dealing with a large number of issues. You might have to deal with hardware problems. You might have to deal with software problems. The system may crash at any point of time. The computer may crash at any point of time. You have people who are not able to access because they have not followed the procedure that is required for accessing. So really, it is a full-time assignment, and a dedicated team is necessary to ensure that the systems are in place at all points of time. Issues will arise. They have to be followed up. Now, it can't be said that if there is a problem today, I will attend to that problem after 2 or 3 days. It has to be attended to immediately. So you need experts who are within the court system who can attend to these problems. So really, it is a huge problem in terms of manpower management, in terms of recruitment, in terms of getting people to attend to issues that may be raised by any judge out of 19,000, any member of the staff out of 19,000 or more. So really, it is a full-time job. And what we therefore did was we set up something called the E-Committee in every court complex. It is not that there was only one Supreme Court E-Committee of which I was the chairman. We had E-Committees in every court complex. So the problem could be attended to locally, it could be looked at locally, and if there was a problem of some serious nature, then it could be referred to the E-Committee in the Supreme Court, and the E-Committee would look into it. Fortunately, we did not have that situation arising, and we were able to manage the computerization of the courts. Now, what were the benefits that we obtained from this? I think one of the biggest achievement of the computerization of the courts is something called the National Judicial Data Grid, NJDG, National Judicial Data Grid. Now, through this National Judicial Data Grid, every order that is passed in every court is uploaded on the National Judicial Data Grid. So sitting in my house as a litigant or sitting in my office as a lawyer, I can access the National Judicial Data Grid and find out what has happened in my case. Now, we have something like 80 million judgments that are available on the National Judicial Data Grid. So at any point of time, if anybody wants to look at what has happened in a particular case, in a particular judgment, that can be accessed. This is, I think, very, very important, and this has led to the courts and the administrators understanding what are the problems that are being faced by the Indian judiciary. They know how many cases are pending in every court. They know how many years the cases are pending. They know the kind of cases that are pending. And for the improvement or the reform of the overall judicial system, this information becomes important. So the administrators, the policy makers, members of parliament, judges, they know that, well, in a particular case, in a particular court, or in a particular region, there is a problem which needs to be attended to. There may be vacancies. There may be a very large number of a particular kind of cases. Maybe theft, criminal cases, maybe civil cases of a particular kind, breach of contract, for example. So in all these matters, the planning can be taken care of and the problems attended to, so that the justice delivery system in India becomes a vibrant system which can help the litigants. So really the National Judicial Data Grid is extremely useful, and I think to a very large extent it has transformed the functioning of the judiciary in India and the understanding of the judiciary in India by lawyers and litigants. Another advantage that we have had is the use of video conferencing. Programs like this are being conducted almost on a daily basis. During the COVID period, India had a very bad time and we had a very strict lockdown during the COVID pandemic. That's when the use of video conferencing became important. So the judges could sit in their home, the lawyers could sit in their home and argue cases. Now, we had a lockdown, we had a very serious lockdown. And if video conferencing was not available, the justice system would have collapsed. There were thousands of people who were in jail. Now, how do you provide bail to them if there is no system functioning? So through the process of video conferencing, we were in a position to provide access to justice to everybody. It was not like as if it was back to normal, of course not. But we were able to provide essential services. Urgent cases were taken up, criminal cases were taken up, bail matters were taken up, so that people are not in jail for no rhyme or reason, only because the system is not functioning. So really, the provision for training of the lawyers, judges, staff, providing hardware to them, video conferencing facilities, access to internet. All this, I think, made a huge difference so far as the Indian judiciary is concerned during the period of the COVID pandemic that we had and the lockdown that we had. What about the judges themselves? Through this process of going through the National Judicial Data Grid, ensuring that justice is provided to the litigants, we have been able to monitor the performance of judges. For this, we have used digital technology to a very, very large extent. I will give you an example. A judge is expected to put up the order that has been passed or all the orders that have been passed on the National Judicial Data Grid before the end of the day. Now, there may be some problems here and there, so we have kept a cutoff time at 12 midnight. So by 12 midnight, all the orders that have been passed by every judge in the country, they have to be put up on the National Judicial Data Grid. And if they are not put up, what the computer does is it will process the information that it has got, and in the morning, it will send an SMS to the judge that in a particular case, you have not uploaded the data. You have not uploaded the order that you have passed. So the judge is told automatically through a system that we have devised, a software that we have devised, an application that we have devised, that the judge is kept informed of some instances where the data has not been uploaded. Now, this helps in the performance monitoring of the judge, because if the judge is regularly not putting up the information on the National Judicial Data Grid, we know that the judge is not doing his job properly. If the judge is diligent, we know that the judge is diligent. The orders that are uploaded on the National Judicial Data Grid, we know we can go through them, we can analyze them. And through this process, we can monitor the performance of judges. So it is really the transformation that has taken place has ensured that the judiciary becomes more efficient and that the quality of justice improves and that timely justice is given. People don't have to wait to find out what has happened. They know exactly what has happened. They have to access the computer system and they will get the information. Now, we in India have a very large number of cases. I mean, very, very large number of cases. 49 million cases are pending in the courts. It's a very, very large number. Now, to remove the burden or to reduce the burden of judges in some category of cases which are of a minor nature, we came up with an idea of something called a virtual court. Now, we have experimented with that virtual court in the case of traffic offenses. The experience has been that if there is a traffic offense, then the person normally goes to the court, pleads guilty and says, all right, what is the fine that I have to pay? And the judge will say, all right, you have to pay 500 rupees as fine or 1000 rupees as fine, whatever the nature of the offense. Now, because of the volume of traffic and so on, and there are persons who violate the traffic rules, there are a large number of footfalls on a daily basis and a large number of courts. In Delhi, at one point of time, we had 16 traffic courts that were dealing with these traffic offenses. So 16 judges were doing nothing but traffic offenses. So we came out with this idea of a virtual court where a person who has committed a traffic offense can first of all find out whether he has committed any traffic offense by putting in the number of his vehicle by putting in the number of his driving license. So you can actually go to the website and see whether there is any traffic offense that is pending against you. If there is no traffic offense pending against you, of course, there's no problem. But if there is a traffic offense that you have committed and the police has sent you a summons in respect of that traffic offense, you don't have to go to court to deposit the fine or to plead guilty. You have the option, sitting in your office in front of a computer, you can say, I plead guilty. And we have programmed it so that the minimum amount of fine is to be paid. So I can say that I plead guilty, and the computer will tell me that you have to pay a fine of say 500 rupees or 1000 rupees. And through the digital payment system, I can pay that fine. Now, this facility is available to me 24 hours a day. There is no judge who is present. I am interacting with the computer. I am telling the computer that I am guilty. And the computer is telling me what is the fine. And through the digital payment system, I pay that fine. I can do it at 10 o'clock at night. I can do it at 11 o'clock at night. I can do it at 6 o'clock in the morning. It doesn't matter. So through this process, all these judges, 16 judges that we had in Delhi, they were all replaced by one computer. And that computer is functioning 24 hours a day. I also have the option of telling the computer, no, I do not plead guilty. I did not commit any traffic offense, and I want to contest that case. The computer will record it and will tell me that, all right, you have pleaded not guilty. You go to a particular court on a particular date and your case will be taken out. So it is not as if I have to plead guilty in every case. No, I can plead not guilty and ask for a hearing in the court. But our experience has shown that almost 99% of the traffic offenses, the persons plead guilty and they pay the fine through the online payment system. So the number of persons coming to the courts has reduced. It is convenient for the litigants or the traffic offenders because they can pay the fine at any point of time. The paperwork of receiving the fine and so on is all eliminated because everything is done through the online payment system. So this has succeeded to a very large extent in 3 provinces, 3 states of India, particularly with regard to traffic offenses. We are now looking at extending this to other minor offenses where prison sentence is not an option, where it is only a fine that is an option. For example, delay in paying property tax, delay in making some other payment. So all that has to be done is some fine has to be paid or some penalty has to be paid or some interest has to be paid. All that can be done through the computer. Now, the result of this is that many judges across the country have stopped doing traffic work and their work is being held and conducted by one computer. That is all that you need. This is, I think, a huge transformation that has taken place in the justice delivery system. Now, where do we go from here? we have achieved a lot. We have provided hardware. We have provided robust software. We have made it accessible to lawyers. We have made it accessible to litigants. It has benefited judges. It has benefited policy makers. It has benefited decision makers. It has benefited the police. It has benefited those who are in jail and do not have easy access to lawyers and to the courts. By and large, it has, helped just about everybody who is involved in the justice delivery system. So where do we go from here? Now, one is, the lessons that we have learned during the COVID pandemic. The most important lesson that we have learned is that digital transformation is absolutely necessary. We cannot avoid it. If we were not prepared with VC, video conferencing systems, if we were not prepared with computers, the entire justice delivery system would have collapsed. People would have had to stay in jail. Why? Because the courts are closed. Why? Because there is COVID. Why? Because there is a lockdown. But we were able to overcome these challenges only because of the digital transformation that has taken place over the years. Let me repeat, it is not something that can be done overnight, but it is something which requires efforts of months together, sometimes years, because training is a huge problem. Training of a large number of people is a huge problem. So the first lesson is that digital transformation is absolutely important. The second lesson, and I think this is where we need to now proceed, is to look at artificial intelligence and how artificial intelligence can help the judiciary. Like I mentioned, we have 80 million judgments on the National Judicial Data Grid. Physically, it is impossible for anybody to analyze these judgments. It can't be done. We need a computer with a very good algorithm to analyze these judgments. So segregation of these judgments is absolutely important. Broad segregation, yes, criminal, civil. But then you have different kinds of criminal cases. You could have murder, you could have theft, you could have rape, you could have cybercrime. The computer can sort this out. The computer can say that, well, this is a case of murder. This is a case of rape. This is a case of theft. This is a civil dispute concerning breach of contract. This is a civil dispute concerning property. This is a civil dispute concerning, some other issue that may arise. So through this process, the justice delivery system can be improved to a considerable extent, where the computer will analyze the judgments, will tell you of the nature of the cases that have been coming, the nature of the decisions that have been taken, how many persons have been acquitted in a particular criminal offense. In murder, how many people have been acquitted? How many people have been convicted? Those who have been acquitted, why have they been acquitted? Is it because the evidence was not good enough? Or is it because the witnesses did not come forward? What is the reason? Why were there so many convictions? Is it because the witnesses came forward? Is it because the investigation by the police was good? These are all questions that can be answered through a good program that is prepared for the purposes of artificial intelligence. For artificial intelligence, you need a very large database. It cannot be done, with 10 or 20 or maybe 100 or even 1,000 data sets. You need data sets that run into thousands. They say a minimum of 40,000 is required. So once we are in a position to get all these data sets in place on a computer, the computer will do the work for us. And that's how the artificial intelligence system will work. But the challenge is, it's easy to talk about artificial intelligence. Computer will do the work, yes. But the challenge is preparing a first-class algorithm, a first-class software, which the computer can then use for the analysis. If we do not have a good software, if we do not have a good algorithm, well, we can go on talking about artificial intelligence, but we will make no progress. So this is a very, very big challenge. And we in the Indian judiciary are trying to do it, but it's very difficult. It's not easy. We have the data sets, we have the resources, but like I said, it's a full-time assignment. We need to have dedicated people who can actually do this work of preparing a software. It will take a very long time. I'm afraid it will take more than a year. The process has started. When it will end, I cannot say. But once that happens, once we are able to introduce artificial intelligence in the judiciary, you can be rest assured that the problems that we face, of large number of cases will disappear. To some extent, to a very limited extent, I will say, mediation is being done through computers. So you have a good algorithm for that, and it can be done. The challenge really is for the justice delivery system to accept, to adopt, and to utilize artificial intelligence in justice delivery. So I'm looking forward to that, and let us see. I hope we are in a position to do it in the next maybe 1 or 2 years and transform justice delivery in India. Thank you very much. That is all that I have to say. And if there are any questions, I will certainly try to answer them. Thank you.
Thank you, Just Loker. Let me then moderate and ask also from participants if they have any question, even in Thai. And now, please can you change? I'm not sure if you change the interpretation mode to English, so translator can then translate from Thai to English. Okay, if so. ครับครับทุกท่านครับหลังจากที่ได้ฟังประสบการณ์จากท่านผู้พิพากษานะครับ Judge Locker ที่เป็นประสบการณ์ตรงจากที่ท่านได้ทำงานของประเทศอินเดียถ้าเกิดมีใครมีคำถามถึงท่านผู้พิพากษาไหมครับเป็นโอกาสที่จะได้สอบถามจากผู้ที่ได้ทำงานโดยตรงครับสามารถยกมือได้เลยนะครับถ้าเกิดใครมีคำถามครับ
Okay, I have received one question on the chat box. Can I answer that?
ครับเชิญเลยครับสามารถตอบได้เลยครับในแชทบอกครับ Yes, please answer if there is any question in chat box, please.
Yeah, the question that I have received on the chat box is that which software you classify as first-class software as you mentioned earlier. The software has been developed by us. There are two kinds of software. One is, proprietary software that you purchase a license. For example, if you buy a computer, a Microsoft computer, you will get a Microsoft license along with it, MS Office or whatever. Or if you buy an Apple computer, you will get a license. You will have to purchase a license to use the Apple software. But what we are using is free open source software. Free open source software is something that we have to develop. We have that liberty to develop our own software. So really, there is no first class software that we have obtained. We have developed our own software, and we can change it at any point of time. You see, so if during the software we want to add something, we have added, for example, we have added gender, all right? We have added whether the litigant is a senior citizen or not a senior citizen. Now, if we want to add whether the litigant is suffering from any physical disability, we can modify the software and put that information in. So we know that we have so many persons belonging to, say, the female gender. Out of them, so many of them are senior citizens. And out of those senior citizens, so many of them are, physically disabled or physically challenged. So the development of the software is done by us. What do we want? And we develop the software on that basis. And like I said, it is free. So whatever software we have, we think it is serving our purpose.
สวัสดีค่ะดิฉันเป็นศิริรัตน์สุขโกตินะคะเป็นผู้ช่วยผู้พิพากษาศาลอุทธรณ์นะคะอยากทราบว่าในระบบที่จะมีการพัฒนาในระบบที่ว่าตัดสินที่ใช้ AI คล้ายๆ AI ในการตัดสินคดีเช่นคดีจราจรนะคะถ้าหากจำเลยมีเหตุที่จะขอบรรเทาโทษหรือว่าขอให้ลดหย่อนผ่อนโทษ AI มันก็ทำไม่ได้ใช่ไหมคะหรือว่ามันจะเป็นแรงค์ AI สามารถทำตรงนี้ได้ไหมคะเช่นสมมติว่าขับรถฝ่าไฟแดงแล้วจริงๆของเมืองไทยเนี่ยถ้าขับรถฝ่าไฟแดงก็คือว่าถ้าจำเลยรับสารภาพมันสามารถเปรียบเทียบปรับในชั้นพนักงานสอบสวนได้ค่ะแต่ถ้าสมมติว่าคดีมาถึงศาลจำเลยปฏิเสธในชั้นสอบสวนแล้วเกิดจำเลยเปลี่ยนใจในชั้นศาลว่าจะรับสารภาพเช่นนี้ในระบบของอินเดียเนี่ยเป็นข้อหาขับรถฝ่าไฟแดงที่มีโทษปรับคงตัวหรือว่าเป็นแรงค์ของโทษปรับถ้าหากว่าเป็นแรงค์เช่นปรับ500 ถึง 1,000 บาทอย่างเนี้ยตัวคอมพิวเตอร์มันจะประมวลผลยังไงว่าควรจะปรับเท่าไหร่ถ้าสมมติว่าจำเลยมีเหตุที่จะขอลงโทษสถานเบาอะค่ะเช่นจำเลยจะมีปัญหาเรื่องเศรษฐกิจในครอบครัวอะไรอย่างเงี้ยค่ะขอบคุณค่ะ
Okay, the second question that I have received on the chat box says, how do you protect case data in your national judicial data grid? Yes, this is important. We have experts, who have prepared a firewall so that, there is no possibility of hacking. This is, of course, very highly technical. The experts know how to manage the firewall, how to ensure that, hacking is not done. We use, on a daily basis, passwords for our email so that people cannot get into our email inbox. But the experts have their own, technical way of ensuring that, hackers do not get into it. So that is how it is being done. I really can't say what is the technical method in which it is done, but we have these experts who ensure that the data is secure. And it's not as if it is secure in one place, it is secure in at least 3 places. So even if there is a problem in one place, the data will be available in 2 other places. The other question that I have received is, does the use of electronic court procedure in India inconsistent with the right to confrontation of the defendant, if any, under the Indian procedural law? No. My answer to that would be no, and yes, to some extent. You see, it is an option that is available. If I want to examine a witness, through the digital procedure, it depends upon the lawyer for the other side, whether he agrees to the procedure or he does not agree to the procedure. If he does not agree to the procedure, then the parties will have to, of course, come to the court physically. But by and large, one of the ways in which we have overcome this problem is that the witness is isolated. There can be representatives of both the parties, present in that room or near that room, who can be sure that the witness is not being pressurized. So to that extent, we have been able to overcome the problem. But yes, there are cases where the lawyers insist that no, we would like to examine the witness, confront him physically. In that event, it is being done physically. But in civil cases, by and large, the experience has been that the lawyers are quite happy if it is done through video conference. But yes, that is a challenge, and it depends upon how the lawyers react to the suggestion.
Just local, there was a asking question. The question was that in Thailand, there are level of fine, right, for the traffic case. So, but in the case of India, when you have pledged guilty in the computerized system, right? So, if there is a negotiation or the request of that person, right, to reduce the fee, the fine, so how that can happen with computerized system, or how you deal with that?
With regard to, you are asking with regard to the virtual court and traffic offenses?
Yes, traffic case, because you mentioned that people can say guilty in front of the computer, right? And it will a fixed fine, right? But if there is negotiation to reduce from that person, so how you deal with that? Yeah,
you see, what we have done, because this is on a pilot basis, what we have done is we have said it will be the minimum fine, right? So the law says that for this particular offense, the minimum fine is 500. So we say, all right, you pay 500. There can't be a negotiation on less than 500 because the law does not permit it. Okay. Now, later on, as this virtual court system picks up, then we will have the system where, for these kind of offenses, again, that's artificial intelligence, that the fine that is being imposed is not 500 rupees, it is 800 rupees, right? Then the computer will say, I'm talking about artificial intelligence, and at a later stage, computer will say the fine is 800 rupees. Then I can negotiate. Then I can say, oh no, 800 is too much. And if necessary, it can be referred to a judge, to a human judge, to say that, well, should it be 800 or should it be less than 800? But that will come at a later stage, because today we are taking the minimum fine, right?
another question in the chat box in Thai is that you mentioned about the case of a traffic case, right? But that use computerized decision, right? And also the AI as well. So is there any other case that use the AI to make decision or guide judge to make decision in addition to that traffic case?
Yes. We are now looking at, we have something called property tax, right? So if you own property, you have to pay some tax on that. Again, it's a mechanical process. So if I don't pay the tax, all right, I will get a message from the computer that you had to pay the tax by 30th of June, but you have not paid the tax. All right, so you can pay it today, otherwise from tomorrow onwards, there will be a fine. Now, I can pay the tax, and again, the minimum fine will be imposed if I delay. So really, for some of these minor offenses, petty offenses, property tax is one of them that I can think of. Shops, I have to close my shop at 8 o'clock at night, but I do not close it at 8 o'clock at night. Then the beat constable in that area will put a note and say that this person did not close his shop at 8 o'clock at night. So therefore, he has committed an offense under the Shop and Establishment Act. So therefore, penalty has to be imposed. Now, what is the minimum penalty for that? The minimum penalty for that is, say, 200 rupees. So gradually, starting from traffic offenses, like I said, is a pilot which has been successful. We are now going to go into property tax. We are now going to go into other areas, like I said, shops. There could be so many other, small offenses where only a fine is the punishment. So this process is gradual, and it will be expanded in due course of time.
Okay, we have a question in the chat box. Please give information about mechanic official that can help judge in the virtual court.
Sorry, I have not been able to understand this question.
Yeah, me too. คุณพักครับ สามารถที่จะถามโดยตรงได้เลยนะครับ Okay. Let's see other questions. If there is any other question, we still have a few minutes left. มีใครมีคำถามเพิ่มเติมสามารถถามได้นะช่วงนี้นะครับ
Excuse me. I asked about the information about technical person. Help judge to teach judge how to prove the theory, the correctly of the document to present to the court, or other evidence to send to the court, and how technical officer can help to teach that. In Indian, we have this process. How you do about this process in Indian?
Yeah. Okay, I understand your question now. You see, if I want to file something electronically in a digital format, right, there is a standard procedure that I have to follow. For example, the size of the paper, all right, the font of the script, all right, the margin that I have to leave on the left-hand side and the right-hand side, top, bottom, and so on. So this procedure is prescribed. Then through the computer system, it could either be by email, or it could even be by the software that has been prepared. I do the filing. It reaches the court, and the officer in the court will then scrutinize and see whether I have done the filing in accordance with the procedure that is prescribed. If there is nothing wrong in the procedure that I have followed and the method of filing is correct, then the document will be accepted. But if there is a problem and the officer in the court says that, well, for example, the document has not been notarized, there is no notary who has given the signature on the document, then that communication will be sent to me that, well, your document is not notarized, please have it notarized and then send it to us. So these objections can be taken care of through the computer and the officer in the court. There have been instances where because of a difficulty in communication through email or through some other process, a video conference can be held. So it is as good as my going there and filing physically and discussing with the officer what is to be done. So these are challenges that we face on a day-to-day basis. I mean, it is not something that is perfect. But through video conferencing, we are able to resolve some of these issues. And then the document is then given to the judges for reading and deciding the case. So this is the process that we are utilizing. There are problems. I'm not saying that it is 100% perfect. There are problems, but we are overcoming them as they arise.
Thank you, Judge Locker. I have in my chat box some question, a few questions, but it's related to the same question. So, in case of criminal case, how do you use video conferencing in criminal case, and do you have any criteria to use video conferencing in criminal case or not? How is that require a consent from parties to use?
Yes, it is required. You see, there are two kinds of video conferencing that we do in criminal cases. One is with a person who is in jail, right? He can also participate in the case through jail. In that event, of course, there is no question of any consent because he's himself participating. But when you are recording evidence or when arguments are being heard, then the consent of both the lawyers is necessary. Otherwise, there can be an allegation that the witness is being pressurized or the witness is being tutored. So safeguards have been put in. And those safeguards are that the witness is isolated, kept in a neutral place, right? Lawyers for both the sides or their representatives can visit that place. They can be present in that place, either physically or even virtually, online. So there are these safeguards. We have prepared some of these guidelines. And if those guidelines are acceptable to the lawyers, we go ahead with it. If one of the lawyers insists that no, you see, it has to be done physically, well, then it has to be done physically. But those safeguards and guidelines are there.
Thank you, Justice Locker. I'm mindful of the time for this session. Actually, there are many questions about this. So perhaps in the future, we may organize this type of technical issue into more detail as well to make sure that I understand about. But for now, let me thank you on behalf of participants to Justice Madan Locker for his insightful hands-on experience and also questions or the answer that really a practical answer to all the participants. Thank you so much for Justice Madan Locker. Thank you so much. Thank you.
Thank you.
Okay. Now, mindful of the time, so now I would like to move to another session with experience from to we invite judge from Malaysia to share experience from Malaysia. So Judge Honorable Judge Dayang Elim Narisa Abang Ahmad, for her education, she graduated PhD. She is a PhD candidate, University of Malaya, and also joined Malaysian judiciary since 2002, and held various judicial positions. Her current position is judge in the section court at Kuching, Sarawak, Malaysia. So she is a part of the court management team responsible in developing and implementing the computerization system of Sabah and Sarawak court. And also she is a part of working group of ASEAN governance framework on AI. So she will speak on the issue of reimagining court technology, the experience of Sabah and Sarawak. Let me welcome Honorable Judge Dayang Elin Nalisa Binti Abang Ahmed. The floor is yours.
Good morning, honorable judges, ladies and gentlemen. Thank you for the kind introduction. Can you hear me?
Yes, we can hear you.
I'm truly honored to be here and to be able to share our story with such a distinguished group. I must first state at this very outset that the courts in West Malaysia and East Malaysia have different computerization system and managed by different system developers. My presentation today is focused on the digital transformation in East Malaysia, i.e. in the courts in the state of Sabah and Sarawak. Now, when we mention technology within the courts, it is often considered synonymous with large computer systems that store data, produce reports, case documents, and basic technologies such as computers, printers, scanners, internet connections, or what is often referred to as digitization. Now, within the Malaysian context, technologies have proliferated since the 1990s. It then paved way to digitalizations and have produced numerous organizational implications in terms of improvement in the quality and transparency of the judicial process, increase in the level of access to the judiciary, and increase in the confidence of the citizens and businesses in the judicial system. The impacts of digitization and digitalization on the functioning of the judiciary in Malaysia are mostly positive. In 2006, the Chief Judge of the High Court of Sabah and Sarawak then, Tun Richard Malanjum, had introduced a major transformation in the courts and judiciary with the computerization of the court system. The system is known as Integrated Court System, or short for ICS, and the project was undertaken by the state-owned company in Sarawak called SINS, Sarawak Information System, Sdn Bhd. Now, what you see here is the table, which is an overview of the services that have been digitalized to date. We started with the basic functions such as case management, manual file tracking, court recording and transcribing for hearing, exhibit presentation system, reports, followed by enhancements of those modules in the subsequent years. All right, next slide. Before I go further, I would like to show you the map of Borneo. The blue color represents the state of Sabah and the yellow color represents the state of Sarawak. There are 7 main courts in the state of Sabah and Sarawak, and each main court administers the smaller circuit courts under its jurisdiction. The registry of the High Court of Sabah and Sarawak now is located at Kota Kinabalu, Sabah. Now, I will briefly go through the problems that we encountered before the use of technology. Prior to the transformation, it is a known fact that backlog of cases was a major problem facing the Malaysian judiciary. The backlog naturally indicated the low performance of the judges and officers in handling the cases, and this led to low public confidence. The cases of missing files and dockets were rampant and contributed towards the adjournment and delay in disposing cases. On the part of the stakeholders, lawyers need to travel to court to file and collect documents or to check the status of their cases. Now, information took time retrieving as they were kept in manual books and dockets, and some of which were not even updated. there were duplicity of works and longer time were taken to complete a certain task, while the accuracy could not be guaranteed. Now, I will discuss the impact of digital transformation from three primary aspects. Number one is the court process and transparency. Two, I will talk on productivity and efficiency. And three, reskilling of human resource. First one, court process and transparency. As I mentioned earlier, our system ICS broadly consists of case management system for the court, case management system for the advocate and agencies, court recording and transcription system, short for CRT, and VCOS, i.e. video conferencing of Sabah and Sarawak, and finally iKiosk. These are our main modules for our integrated court system. Next year, these will be expanded to 11 separate modules under the name of EKSS. Now, this was a common sight in the past. Lawyers, process servers, and members of the public queuing to file court documents and sealed documents were returned by placing them in the pigeonholes. We often received complaints from the litigants and lawyers back then that they never received the documents. I will highlight mostly about the functions of the CMS for the court. The CMS is an internet-based software application designed to manage and monitor court cases from the point of registration right to the disposal. It incorporates the e-filing module, the planner module, the master listing module, the appeal module, and some of the administration module, as you can see on the screen. Now, when a case is e-filed by the lawyers or agencies, the master list of each court is automatically updated and auto-scheduled with a mention or hearing date. Judges and officers are able to view and update their individual court schedules. As can be seen on the screen, the planner categorized the nature of our cases into M, mention, H for hearing, and T for trial. The e-filing module allows the lawyers to upload their pleadings and documents into the CMS system and make payment online via the participating banks. When a document is e-filed, the court will get a notification and the system will automatically assign first a case number, second an enclosure number for the document, third a hearing date, and also the presiding judge. And this goes in accordance to different case codes and applications. This has also resolved the unwarranted allegation of judge selection or forum shopping by litigants and their lawyers. The system will automatically return the documents after it has been digitally verified, signed, and sealed by the court. Now, each of the court documents bears a verification code for security purposes. It is our court policy that all documents must be processed and returned within 24 hours. If there is a lapse in the process, the CMS will send notifications to the officer in charge, the judges, and the chief judge. The customary complaints by litigants and their lawyers of not having received their document from the court is, I must say now, history. From the moment a case is registered into the CMS, the monitoring is made possible as court administrators could access into the system and obtain any information on the matters handled by each court under its supervision. Now, next slide will show how the e-payment looks like, and these are the lists of the participating banks which the lawyers can select from their end. Next is the digital signature and the court seal affixed on the court document. All right. Now, in the year 2020, e-filing and CMS, the system, was made accessible via mobile apps. Lawyers can now e-file documents, view listing of cases and schedules, and search for cases using only their mobile phones. What you are seeing on the screen is the interface for the mobile apps. Right, next feature is an additional module which was added in 2020, the self-represented litigant module. All right, the SRL, or the self-represented litigants module, provide basic information for SRL to initiate or to defend an action. It gives you basic information, as you can see there, general information, and it answers frequently asked questions: how to file a claim, how to defend a claim, what to do in a trial, what if I disagree with the decision of the judge, and what to do with the court order. These are basic FAQs, and it provides a platform for self-represented litigants to prepare their own court documents. This is part of our effort in ensuring accessibility to justice and to reduce digital divide. All right, next slide. Integration with relevant agencies such as the Chemist Department and Prison Authority is another very important feature of the system. Prior to this, the court depended on the police or the prosecuting officers to notify us on the progress of chemist report, especially for drug offenses. This sometimes resulted in a necessary delay and encouraged abuse of the court process. Now, with this feature, the status of the report is available online. As you can see, there is an arrow pointing there. That is a notification, and this is accessible by the court. Another important integration, as I mentioned earlier, is the integration with the prison department that allows the court to generate e-warrants to the prison department via the system. It gives advance notice to the prison department before a convicted person is escorted to the court, save time and manpower, and not to mention papers. Since everything is in the court's database, the court's process and handling of matters become transparent, and in the long run, the confidence of the public is enhanced. The next slide shows some of the other government agencies that we are also connected with. For example, the police department, the FPX Banking Online, the Registration Department of Malaysia, the Sabah and Sarawak Law Societies. I will move on to the next point, which is productivity and efficiency. Now, the CMS also served as a monitoring and administrative tool. Prior to the implementation of the CMS, the common complaints that we normally receive is delay in the fixture of hearing, interlocutory trial or appeal dates, inactive and outstanding cases, and sometimes judgment are not delivered within the prescribed time. Now, with the CMS, email notifications are automatically sent to the chief judge, judges, and officers in charge when this happens. Decisions and grants of judgment are pending for more than 60 days, inactive cases for 90 days or more, interlocutory applications not fixed for hearing within 60 days, appeal cases not fixed for hearing within 3 months from the date of the filing of the notice of appeal. Then the master list will turn to these colors, red, orange, red, yellow, green, or blue at the same time. Judges and officers are appraised of the number and status of cases in their courts, the number of pending decisions that you have, the number of outstanding judgments, and other relevant details pertaining to your caseload. This provides as a useful notification alert system for the chief judge, as well as the judges and all the judicial officers. This system also automatically and accurately, I must say, generates monthly statistics and other reports as may be required by the statistics unit of the Malaysian judiciary. This e-statistics minimizes human errors as usually found in manual preparation. Now, when the cases exceed the prescribed timeline, the judges or officers would see these blinking alerts in the master list to help them keep track of the cases. Now, the timeline that you see on the screen are fixed by the chief judge as an ideal period of disposal. Next is a timesheet report. This is the system automatically does the time tracking for the daily performances of judges and judicial officers. For instance, how long do you sit in court, duration of a sitting, and generates a report as and when required. Now, the timesheet is intended to shield judges and judicial officers against any allegation of non-performance in open courts. All right, next slide. This is one of the most important features in the CMS, the electronic or virtual file. Virtual files have replaced the conventional hard copy dockets of file, and as you can see from the screen, it contains all the cost papers uploaded to the CMS by way of e-filing. every case has its own virtual file. Now, what is shown is an example of a virtual file. It gives you the date of filing, the document type, and description of the document, and all notes of proceedings and judgment written by the judges or judicial officers are also uploaded automatically into the virtual files. Lawyers for litigants are also allowed access to their own case via online CMS for advocate and agencies. This allows the judge or judicial officers to access the court file anytime and anywhere upon logging in. The need to carry dockets home is no longer there, and the virtual files have also resulted in operational efficiencies such as reduced costs on the use of papers, files, and personnel, while increasing productivity with clerical errors almost unknown. The feature of the virtual file eliminated the repetitive manual processes involving manpower, such as file searchers and court clerks. Now, the common problems of missing files that had earlier on caused adjournments of hearings and delays in returning of documents to lawyers and litigants no longer exist. We would also recall that one of the components of CMS is video conferencing of Sabah and Sarawak courts, or short VCOS, in short VCOS. Even before COVID-19 pandemic hits us in 2020, this system was already introduced in Sabah and Sarawak to overcome the problems faced by lawyers who have to travel long distance to appear in court on time. And this is due to the peculiar geographical features in Sabah and Sarawak courts. Now, the VC facilities are available for court proceedings in the major towns of Sabah and Sarawak, the 7 main stations that you have seen earlier, and it was also Zoom compatible. However, VCOS specifically is managed by the court's own infrastructure, and we have a dedicated server, hence better security compared to Zoom. In 2021, the VCOS facility with prison authority was set up, and its use was extended for the extension of remand and mention of simple criminal matters. This was mostly used during COVID-19 situation to reduce physical contact between the inmates and the court officers and staff. Now, with digital transformation, courtrooms become geographically accessible, again, anytime and anywhere, and available to all. Next feature is an e-review. This is a favorite feature of mine that dispenses with the need of lawyers to travel to court just to get simple directions or another mention date, pending, for example, service of course papers or close of pleadings, for example. With e-reviews, the exchanges between the lawyers and the court will be automatically converted into notes of proceedings and will then form part of the virtual file. I will move on to the third component of the ICS, the court recording transcription or AVOTEX system. AVOTEX is a software system used in our open courts. It consists of video and audio recordings to allow court transcribers to produce notes of proceedings real-time or live during the trial. Now, the software AVOTEX facilitates editing, recording, and archiving of audio and video of the court proceedings into the CMS for record purposes. With AVOTEX, the transcripts are available to the parties almost instantaneously. In the past, we had problems with the preparation of notes of proceedings. It took weeks to prepare and sometimes months to be completed, and hence delays in trials. Now, further, during the court proceedings, the notes of proceedings typed by trained court transcribers can be viewed by the judge, lawyers, accused, and witnesses from their respective screens. Last but not least, ICOS, or AI court sentencing, was added to the CMS in the year 2020. We utilized the data in the CMS, and we felt that leveraging on AI would help improve court performance while enhancing public confidence through consistency in the sentence passed. Piloted for drugs offenses, with more criminal offenses in the pipeline, AI was introduced to achieve parity and transparency in sentencing. Now, at present, AI is used in the magistrates' courts only and has been applied by the magistrate in over 5,000 cases throughout Sabah and Sarawak courts. This is some of the screen captures from AI. As you can see here, it provides recommendation in the form of percentage. It also provides analysis on the rampancy of the offenses, and it has a screen capture or an interface for the magistrate to key in the relevant parameters for the AI to generate a recommendation prior to sentencing. All right. Now, reskilling of human resource is another important factor that I would like to touch on in this presentation. The digital transformation from a conventional system inevitably resulted in acquisition of skills and reskilling of court officials and staff. Readiness to embrace changes is another important aspect that requires continuous engagement and training for court judges, court staff, and also lawyers, legal practitioners, to ensure that the entire system could be utilized to the fullest extent. Our change management experience finds importance in inclusivity by bringing in all levels of users and stakeholders to participate in the decision-making of the technological applications at the courts. Now, I have shared some of the training sessions that we have conducted, refresher course conducted with some of the participants from Bintulu Sarawak, and also users from Kota Kinabalu Port Sabah, and also lawyers awareness session and refresher courses with lawyers and court users. In conclusion, digital technologies are tools to support the delivery of justice. The effects, as you can see, are not just functional, but promotes values such as fairness and accountability, effectiveness, efficiency, and most importantly, access to justice. Most importantly, I would think that digital transformation has contributed towards a significant disposal of cases, which, after all, is a core function of the courts. I would also like to mention that the ICS won the MSC Malaysia Asia Pacific ICT Award in the year 2008 under the category of the Best E-Government and Services, and also the United Nations World Summit Award in 2009. The ICOS was also featured by Hazanah Research Institute Malaysia and the Gulf Insider Singapore in their recent publication. That concludes my presentation. Thank you very much, and I will try my best to answer questions. Thank you.
Thank you so much for the presentation and insightful presentation, informative presentation as well, that show in even a detail of interface in the websites, but also in the mobile app. So now I will switch to Thai. So, but you can hear me in English if you switch to English mode in the interpretation, no? So let me switch to Thai. ครับก็สวัสดีครับทุกท่านก็หลังจากที่ได้ฟังไปอันนี้เป็นตัวอย่างของประเทศมาเลเซียที่ใช้ในระบบนะครับแล้วก็มีได้รับรางวัลด้วยของเป็นของ UN ด้วยนะครับมีตัวอย่างการใช้ AI ด้วยเพื่อเหมือนมีความคาดการณ์ของคดีเพื่อนำมาช่วยการทำงานของเจ้าหน้าที่ของผู้พิพากษานะครับท่านไหนมีคำถามเกี่ยวกับที่ได้นำเสนอหรือว่าอาจจะเป็นกรณีอื่นที่เกี่ยวข้องกับที่ศาลที่นั่นหรือของมาเลเซียก็สามารถสอบถามได้เลยนะครับสามารถยกมือหรือว่าจะอยู่ในช่องแชทก็ได้ครับซึ่งถ้าในช่องแชทถ้าเป็นภาษาไทยเดี๋ยวผมจะช่วยถามเป็นภาษาอังกฤษให้ทางผู้พิพากษาจากมาเลเซียครับครับมีท่านไหนอยากสอบถามไหมครับถ้าไม่มีผมขออนุญาตถามก่อนแล้วกันนะครับถ้าท่านอื่นยังไม่มีคำถามอยากทราบจากท่านผู้พิพากษาครับว่าที่ใช้ระบบเนี่ยนะครับที่เป็น computerized system เนี่ยเริ่มตั้งแต่ปีไหนแล้วก็จนมาถึงที่เป็นอย่างเวอร์ชันในปัจจุบันเนี่ยใช้เวลานานแค่ไหนถึงปรับเปลี่ยนมาใช้แล้วก็ ได้รับการยอมรับจากผู้พิพากษาของในพื้นที่ในการใช้อย่างกว้างขวางนะครับ
Thank you for the question. We started our journey as early as the 1990s, 1997. That is the basic introduction to what we say the process of digitization, a reference to printers, scanners, converting all the hard copies of documents into the system. We started off with the basic process of digitization. Then we moved on slowly, as I mentioned, as you can see from the slide earlier. Can I just quickly go back to slide number 2? Just give me a moment. Yeah, number 3. Number 3. Give me a moment. Yeah. All right, these are the summary of the ICS services, and this screen indicates the modules that we place emphasis on when we first started and how it later on developed into something which is more the improved version of it. So for example, we started with the case management system in 2007 and the queue management system as well as the e-costis. So when we first started, emphasis was placed on converting hard copies of files into soft copies. That would be the most important, crucial step, I must say, before the rest can come in. And from there, we moved on to our open court hearings. And from there, we developed the radio frequency identification to trace the manual files. And from the manual files, we converted all those into e-files or virtual dockets, as I mentioned earlier. Now, if we talk about acceptance of users, that is the biggest challenge faced by the court, because we were dealing with different levels or competencies of users. For example, there were court staffs who were very, very senior and have been hanging on to hard copy diaries right from the very beginning they started work. And we also have judges who were not technology savvy at all. They did not know how to switch on computers even, and does not even know how to search or look for cases, let alone to what do you call that, to manage everything or information online. So we started off with the basic training for users, and slowly and progressively they get the hang of it. They are now fully dependent on the system. They do not rely on hard copies anymore. We don't see hard copy of diaries around. We don't see statistics or manual papers around anymore. And in fact, even the most senior court staff relied on the system. And of course, the next group of users that we had to deal with back then was the group of lawyers. Resistance from the lawyers is even harder or even more challenging compared to the court users. Lawyers would have their own set of minds and would face issues such as, at that time, whether e-filing would be beneficial for them, issues such as network bandwidth, absence of computers and equipments in their firm, and the fact that they would have to purchase all these in order to be on board with the court. So these are the things that we have to deal with simultaneously with the challenges posed by the court users. But of course, these had to be conducted by way of awareness, training, and also in continuous engagement to find out their ways and literally to hold their hand along this journey. Thank you. I hope I answered your question.
ถัดไปขออนุญาตเชิญท่านสิริรัตน์ยกมือขึ้นถามนะครับ
ค่ะสวัสดีค่ะขออนุญาตสอบถามเกี่ยวกับพยานเอกสารเดี๋ยวนะคะพยานเอกสารที่มีการสแกนเข้าระบบที่ต้องการใช้อ้างเป็นพยานหลักฐานจะทราบได้ยังไงว่ามันคือต้นฉบับเอกสารเพราะว่าในกฎหมายไทยเนี่ยจะมีบทบังคับให้พยานเอกสารบางอย่างจะต้องในการสืบพยานเอกสารจำเป็นต้องนำต้นฉบับมาหรือว่าเป็นสำเนารับรองการถูกต้องทีนี้ถ้าเกิดว่าเขาสแกนเข้ามาเราไม่รู้เลยว่าการรับรองนั้นถูกหรือเปล่าหรือว่ามันคือต้นฉบับหรือเปล่าที่จะรับรองทางของศาลทางมาเลเซียแก้ปัญหาวิธีนี้อย่างไรค่ะขอบคุณค่ะ
Can I just clarify, when you say scanned documents for witnesses, is it? Did I hear the question right? Scan document for witnesses? Scan documents coming from witnesses. Judge, can I confirm that your question relates to scanning of documents from the witnesses?
คือในการสืบพยานนะคะก็คือสืบทางคอนเฟอเรนซ์ถูกไหมคะแล้วก็สืบทางคอนเฟอเรนซ์เดี๋ยวนะค่ะสืบทางคอนเฟอเรนซ์แล้วเขาก็จะมีเอกสารที่ส่งมาล่วงหน้าในระบบอะค่ะทีนี้เอกสารตัวนี้เราจะรู้ได้ยังไงว่ามันคือเอกสารที่แท้จริงหรือว่าจะต้องเอาต้นฉบับมาให้ศาลดูเพราะตอนนี้ของศาลไทยเนี่ยก็คือเอาต้นฉบับมาให้ดูด้วยซึ่งบางทีเขาก็เอามาบ้างไม่เอามาบ้างอะไรอย่างเงี้ยค่ะเราไม่รู้ว่าเราจะตรวจสอบยังไงเพราะหน้าที่เราคือตรวจสอบจากเอกสารที่แท้จริงค่ะขอบคุณค่ะ
I understand the question. Let me try to answer the question. Yeah, we have civil and criminal matters. So the tendering of documents by witnesses in both civil and criminal matters would differ according to our rules and procedure. So for civil cases, what the lawyers would normally do after having completed what we call a discovery process, they will e-file to the court bundle of documents. Bundle of pleadings and bundle of documents, and these would include documents that both parties would rely on in the course of the trial, and also documents that would be tendered through the witnesses that will be called to the court later. So these documents will be e-filed by the lawyers first before the proceeding starts. The fact that these documents had gone through a period of discovery between the two lawyers, the court takes it that these documents have actually complied with the rules of the courts set by the court and the law. And when the documents are e-filed by the lawyer who was already given access to the system, there should not be any issue as to the documents at that stage. Now, when the trial commences and the witnesses were called to the court, or even through virtual hearings, then only these documents would be properly tendered through this witness, and then only the admissibility issues and the authenticity of the issues would be dealt with under our Evidence Act, and these will be dealt with during the course of the trial itself. But the court is satisfied by looking at the documents and from the hearing, from the testimony of the witnesses, that these documents actually complied with the procedural requirement of admissibility and authenticity, then only the court will mark that document as a court exhibit. Otherwise, the e-filing process would start first when the lawyers e-file the bundles of these documents through the system. But the document will not be marked as a court exhibit unless and until the witness who has been called to the court testifies on the authenticity and admissibility of the document, in compliance with our Evidence Act.
ก็คืออาศัยคำรับของคู่ความที่รับกันว่าเอกสารตัวนี้โอเคแล้วศาลก็เลยไม่ต้องไปตรวจสอบว่ามันแท้จริงหรือเปล่าใช่ไหมคะถ้าหากว่าคู่ความโต้แย้งก็ค่อยมาดูกันว่าเป็นเอกสารที่แท้จริงหรือเปล่าใช่ไหมคะขอบคุณค่ะ
That is because our rules provides that for civil cases, the lawyers prior to the trial would have to file 3 bundles. Number 1 is bundle of pleadings, i.e. the pleadings that will be used in the course of the trial and has already been e-filed prior to the case management. Number 2 is documents agreed to by both the parties. These are agreed to as to the authenticity and content. Part B would consist of documents which are agreed to as to authenticity only. So that means during the trial, the lawyer would have to give evidence as to the admissibility. And thirdly, documents which are disputed. So disputed documents would be e-filed by both the parties, but it has to be proved during the trial. So e-filing process does not do away with the procedural requirement under the law at all before a document is admitted as an exhibit. I hope that answers the question.
So in the chat box, it said that that's mean cross-examination and rule of evidence.
Mean
cross-examination of that evidence, right? Yeah. Okay.
Right, the course of the trial. Yes.
Yeah. Another question in the chat box in Thai, so I translate. So when you use technology, including AI, so what's the feedback from citizen and also lawyer? What is a good feedback and also what negative feedback that you receive from them?
Okay, I must state that we started with AI in the year 2020 as a pilot project. It is still very, very new, although we have applied it in, like I mentioned in my presentation, for drug offenses at the magistrate court level. Now, when we talk about feedback, they are positive and negative feedback. Positive feedback is that it has improved the consistency in the quality of the sentence passed by the magistrate. Now, in the past, prior to the implementation of the AI, we have experienced some discrepancy in the sentence passed for the exact same offense. For example, in an offense where the accused person is a first offender and is charged with having in possession methamphetamine 0.05 methamphetamine in possession, a first offender, no previous record of conviction, a single person, not married. These kind of simple facts of the case, Magistrate A would pass a fine of 5,000 ringgit, whereas another Magistrate B, given the same circumstances, would pass a sentence of fine of 8,000 ringgit. There is a difference of 3,000 ringgit there, which is substantial. This is what happened in the past, and the chief judge back then would get complaints letters from lawyers and all that, saying that, look, why are there same cases yet different sentence passed by two different magistrates? So when we introduce AI, the positive feedback is that there seems to be a very consistent sentencing trend passed by all the magistrates in Sabah and Sarawak. In fact, our study even shows that there is a the consistency is very obvious compared to pre-AI pre-AI period. However, the challenges that we are facing now is that to get the buy-in of the lawyers. Lawyers were skeptical in the sense that AI is a new technology, and I think resistance to change is mostly contributed to the fact that, number one, they do not understand what AI is about. Number two, a lack of understanding and awareness on how AI actually works to improve court processes. Number three, the reluctance to embrace AI stemming from the fact that it is not explicitly provided by under any of the Malaysian laws so far. And fourthly, issues as to ethics comes in when we talk about AI. These are some of the positive and negative comments that we get from the users insofar as the implementation of our AI is concerned since the year 2020.
I have another question in the chat box in Thai, so I translate. So do you, is there any system that defendants who is under detention can access to electronic file by themselves?
Okay, whether or not an individual or an accused person under detention who are not represented or who are represented?
It doesn't say who.
Let me try to distinguish the scenario there. Whether or not an accused person, if you talk about a person in detention, and I would assume an accused person in detention would have access to e-file documents, then the answer is no, because e-filing access is only given to lawyers and also court users. So those accused persons who are represented by lawyers, then they would have no problem because they would be communicating through their lawyers who already have access to these documents online. Those unrepresented litigants are not represented by the lawyers would not have access to the e-filing documents, e-file documents. So they would have to revert to the manual process of filing manually through the prison authority with the assistance of the court staff. The court staff would help them to e-file, but they can file manually through the court, and access to the documents would also be manual and not by way of virtual files, because virtual files or CMS is only accessible by lawyers and court officials only.
Okay, I just check if is there any questions other question? Okay, may I have a question from in my chat box now. When you chose the experience of using AI, right? You chose statistics of marriage case, no? And in the AI in your presentation, can you elaborate more a little bit on how AI help in terms of detect, predict the pattern, and also like predictability of the case, whether or not is how to make decision on that? Can you elaborate more how AI help on that, help just on that case?
Okay. All right. When we implemented AI, for example, for drug offenses, as I mentioned earlier, the first step that the court would have to initiate is to identify the parameters of a case in order for the AI to learn. So these parameters are very important because these parameters would help AI learning in the sense that correlations would be established by the algorithm between all these parameters in order to come up with the pattern on the trend of sentencing and why the recommendation is such. So when I mention parameters, that would mean the relevant principles of sentencing on the relevant factors that the court would normally take into account in passing sentence. So for instance, in drug offenses, the factors that the court would normally take into account would be the weight of the drug, the nature of the drug, whether or not the offender is the accused is the first offender, whether or not this is a repeat offense, whether or not the accused was initially remanded for other crimes or remanded for the offense, the ability of the accused to pay the fine, just to name a few. So these parameters were identified by the court before information were extracted from the CMS database in order for the AI to learn. Now, when the algorithm processed all this and the AI learning starts, the court would supervise the learning of the AI in order to make sure that what the AI recommends is consistent with the law. It does not recommend something that is outside the law, for instance. Okay, so at the end of the day, when a recommendation is given to a magistrate, the AI would indicate, for example, 60% probability of a fine and 40% probability of an imprisonment. And this probability is based on the sentencing trend passed by the magistrates in the past. So the AI would also provides the analysis on how it comes to this 60% or 40% recommendation in order for the magistrate to decide. And at the end of the day, our policy is that the magistrate would retain the discretionary power before deciding whether or not to follow the recommendation of the AI or to depart from the recommendation of the AI. Along the way, after having used the system for 2 years, we find that there is consistency in all these patterns passed. For instance, if he is a first offender, the pattern would be between this and that. There is a range of fine. If the person is a repeat offender, there is also a consistency in the range of fine or imprisonment sentence passed by the magistrate. So these patterns were picked up by AI in order to provide a baseline for the magistrate. When there is a baseline, the magistrate would be well-minded that this would be the sentencing trend passed by the other magistrates in the state, and they would not stray far away from the recommendation of the AI. I think that's how AI helped us develop consistency in the long run. I hope that answers the question.
Yes, thank you. So that's answer and how to AI works in practice, no? Is there any other question from participant from Honorable Judge in the room? If not, since okay, no in my chat box and no in the room. If not, since we already have 2 sessions, perhaps we can finish. Say that we finish sessions and just can have 10-minute break before going to another session with experience from Indonesia. No, let me thank you. Thank you, Honorable Judge Dayang Elin Narisa Abang Ahmad, for this insightful presentation, and thank you very much for accept our invitation for this, and hope we can discuss this further and how to exchange knowledge with Thai court in the future as well. Thank you so much.
Very much. Thank you very much. The pleasure is mine. Thank you.
Thank you. Now it's almost 11. I'm about to start the next section. And we have a distinguished speaker from Indonesia. We will start the session in a minute. Okay, now it's 11 already. Thank you everyone for participating. I would like to introduce a distinguished speaker from Indonesia. She graduated for her background. She graduated from Faculty of Bachelor, Master and Master of Business and Constitutional Law Faculty from Gajah Mada University. Now she is working as a judicial judge of law and public relations bureau of Supreme Court of Indonesia. May I invite, please welcome our distinguished speaker, Judge Maria Francisca Walintukan, to speak on experience of Indonesia in digital transformation.
Okay, thank you. Good morning. Let me share my presentation slides. Okay, I think I have some trouble here. Can you share my presentation from there?
Let me open your presentation. Yes. Let me download a little bit.
Okay, thank you.
For 1 minute.
Yes. Okay, thank you very much. Is my voice sound and clear enough?
Clear.
Okay. Okay.
Yes.
Thank you. The Honorable Justice Madan Bimarao Lokur from Supreme Court of Fiji, Honorable Judge Wandayang Elin Narisa binti Abang Ahmad from Session Court of Kuching, Malaysia, the representative from the Court of Justice Thailand, my fellow judges from Supreme Court of Thailand, the President Representative of UNDP Thailand, Mr. Renaud Meyer, Judicial Training Institute of Thailand, and all distinguished participants of this workshop. First of all, I would like to convey my gratitude to Honorable Judge Mr. Bambang Heri Mulyono, Head of Research and Development, Education and Training for Law and Judiciary Agency of the Supreme Court of Indonesia, for proposing me to UNDP Thailand for attending this workshop. Of course, I also thank UNDP Thailand for inviting me and organizing this remarkable workshop. I'm beyond grateful. It's a pleasure and honorable for me to be here for sharing my experiences on this event. Ladies and gentlemen, within this topic, I'm going to spend the next few minutes taking you on a journey where Supreme Court of Indonesia has been able to improve the court system by digitalization. Next slide, please. Okay. Here is Indonesia. Indonesia is the largest archipelago in the world. Indonesian population is approximately 278 million people, the fourth largest population in the world and 14th largest country by area at more or less 1,900,000 square kilometers. It has 34 provinces, multicultural with highly ethnic diversity. Indonesia consists of 5 major islands and predominantly mountainous. Indonesia are separated by seas and clustered on islands. So that's the summary brief of Indonesia. Next slide, please. The geographical condition and the population of Indonesia consequently affect the requirement of the judicial bodies throughout Indonesia. The judicial power must reach out all the regions in Indonesia to bring the justice closer to the society. As we can see on the screen, on the picture, there showed the Indonesian court in all over Indonesia, including 1 Supreme Court, 412 general courts, 441 religious court, including Sharia courts, 23 military court, and 34 administrative court, including high courts. The total number of Indonesian court is 911. It's a massive number of judicial bodies. Of course, it requires many judges, judicial officials, and also infrastructure. In addition, technical matters and case management is the core of business of Supreme Court. Surely, a reliable technology system is important to meet the need of those matters. So the question, how did the management case proceed in Indonesia? Here we are in slide 4. I recall when I was appointed as a judge candidate in 2011, back then the case management in that time still ran conventionally. As an illustration, the plaintiffs had come to the court to register their cases, even just to obtain basic information about a court proceeding. It was really inefficient and much time consuming as well. Of course, this situation emerged complaints and testimonies from justice seekers based on their experiences and also from the findings that concern on judicial reform sector. At last, this condition encouraged the Supreme Court of Indonesia to reform overall the system in its institution, including case and trial management, surveillance system, and judicial apparatus capacity building program, and it all administrative area as well. Next slide, please. Yes. Slide 6. Next slide, yes. Judicial reform aims to promote judiciary that also meet the good judiciary principles. Article 4, paragraph 2 of Law number 48 of 2009 concerning judicial powers stipulates good judiciary principle. The principle of judiciary should be done simply, quickly, and low cost. The Supreme Court of Indonesia Blueprint 2010 until 2035 is a blueprint of judicial reform program and formulates the vision and mission of Indonesian Supreme Court. In the next slide, in order to achieve the vision to bring court excellence values into reality, the Supreme Court of Indonesia has set itself the following mission. First, maintaining judicial independency. Second, providing parties in dispute with fair legal services. Third, increasing the quality of the court leadership. Fourth, increasing credibility and transparency of the court. Yes, Indonesian Supreme Court shows strong commitment in promoting modern judiciary. For 2017 annual report, Supreme Court of Indonesia selected a new era of modern IT-based judiciary as the theme. And the next year, the 2018 annual report was entitled Sustainability of Modernizing of Judiciary. In 2019, the optimization of a sustainable modern judiciary still become a concern. Thereafter, acceleration, creation of a modern judiciary was the title of the annual report of year 2021. For these last 4 years, actualizing modern judiciary becomes main themes of Indonesian Supreme Court annual report in a row. As we can see on the slide, here are the digital application based on IT system which are implemented by Supreme Court of Indonesia. Case tracking system, electronic justice system, electronic trial, electronic budgeting implementation, monitoring and accountability, electronic state asset development and enhancement work application, personnel information system, whistleblowing system, and e-learning. Okay, case tracking system. This system aims to optimize information technology in supporting transparent and accountable public service. In addition, to promote the uniformity of cases management based on IT in all judicial bodies underneath Indonesian Supreme Court. By using this case tracking system, citizens can directly update, monitor, and control court proceeding on website. This system remarkably support public information disclosure. On the other hand, the chief judge of each court can keep continually monitoring and evaluate the performance of the judges and judicial staff. The systems expected that administrative and court process will be faster and court fees will be reduced. Nevertheless, still consider the safety of the data. Okay, on the next slide, electronic justice system. Based on Supreme Court Regulation number 1, 2019 on electronic case and trial administration in court, electronic case and trial administration realizing in e-court system aims to meet the good judiciary principle that is simple, fast, and low cost. The system involves registration, payment, and court summons via electronic media online. Okay, yes. As I mentioned before, this case processing service involves these three main systems. Firstly, e-filing, electronic registration by input the claim documents. E-payment, electronic payment of court fees using virtual account that is easily accessible and efficient for justice seeker, of course. The system aims to prevent corruption practices with no longer conventional payment method. And then e-summon, electronic summon can reduce the post-mail delivery fee. Next slide, please. Yes, thank you. After approximately 5 years implementing electronic justice system, here is the actualization of using e-court throughout Indonesia. As you can see on the picture from the last annual report, this picture shows the implementation of e-court in all over Indonesia. The implementation is surely able to mitigate the geography constraint for justice seeker. And finally, the court is more accessible, in particular for the poor and vulnerable. For example, where the administrative court located in the capital city of a province, so it takes time and high cost for justice seeker who lives miles away in the district or remote area. By this system, the parties are able to see their cases moving through the process. On the next slide, electronic trial, still integrated with e-court, the mechanism of this online litigation system by submitting and exchanging the court documents online. For instance, the documents of responses, counterpleas, rebuttal, and conclusion. Online court as a part of e-court and electronic trials, as we can see on the screen. How does the trial using teleconference conduct? It could be a virtual or hybrid setting. Yes, here's the real picture while online hearing in courtroom, using digital media platform and other information technology equipment, such as Zoom application, computer, and online surveillance cameras. Honestly, I acknowledge that when the pandemic outbreak in Indonesia, this challenging time has pushed the judicial system to move beyond traditional court proceeding or electronic-based system to electronic-based system. Distinguished participants, I would like to share my personal experiences when COVID-19 virus spread extremely in 2020 or 2021 in Indonesia. At that time, I was assigned in Administrative Court of Yogyakarta. Some court officials were infected by this virus. Because of that critical condition, the court temporarily had to be closed. on the other hand, we had to think about the ongoing cases and how the court proceeding conduct. Yes, thanks to the digital system. By using eCourt, the court proceedings still ran well. Although you're working from home, I still could operate the system from home. At last, it could reduce the court visitors, physical contact, and the spreading of COVID-19 virus widely. Okay, EBIMA. EBIMA is stand for Electronic Budgeting, Implementation, Monitoring, and Accountability. To manage financial administrative transparently in Indonesia, Supreme Court and the judicial bodies underneath it, in 2021, yes, last year, Indonesian Supreme Court launched Electronic Budgeting Implementation, Monitoring, and Accountability. This digital application is completed with monitoring features in order to control and supervise budgeting implementation accurately and also real time. Yes, this system is designed to mitigate the risk of unreal financial reports in court, and as the result, it will promote good administration management in judiciary. That's a BIMA for financial management. Next is SADEWA. Okay, SADEWA is stand for Electronic State Asset Development and Enhancement Work Application. For the asset management, we develop an application based on information technology, which has launched last year, same as EBIMA, to meet the administration order on state asset management in court. SADEWA provides an accurate information for making policies on asset management. There's a fun fact about EBIMA and SADEWA. EBIMA, BIMA, and SADEWA are not only abbreviation of these system titles. As we know, BIMA and SADEWA are notable heroes in Hindu epic Mahabharata. So these two applications are uniquely named after these two heroes to remember easily. Okay, the next. Personal information system. In field of human rights resources management of judiciary, Supreme Court of Indonesia has launched Personnel Information System. This system is designed to assist decision-making process in terms of mutation or promoting. In this database system is available all the documents related to the work experiences, qualification, promotion letters, and achievements from each judicial apparatus related to their work experiences. This functional system also can be used to record the attendance of the judicial official. So just in one click, Personnel Information System will record it. The information, whether they work from home or from office or on office leave. This system also encourages the paperless system for sure. Okay, on the next slide, we can see online blowing system. Based on Supreme Court regulation on public complaint mechanism, where it stipulates that all complaints must be submitted through online whistleblowing system of the Supreme Court. Therefore, this essential mechanism-based digital system was launched in 2016 by Indonesian Supreme Court and expected to improve integrity, transparency, accountability, and reputation of the judiciary. When we open the Supreme Court of Indonesia website, as you can see on the screen on the right side, we will encounter SIWAS or online blowing system as announcement on the screen display. It shows that Supreme Court has strong commitment to implement this essential mechanism in building transparency, enhancing integrity, and increasing the public trust in its institution. Ultimately, strengthening the rule of law, of course. This mechanism is designed for public, could be citizen or members of the judicial institution, will be able to participate in promoting judicial integrity by reporting acts of misconduct or inappropriate behavior of judges and judicial officials as well. The system is very confidential because the information about reporters' identity will be classified by the system, and then the reports will be handled by the Supreme Court supervisory agency by focusing on the information, not on the reporters. Yes, on the next slide, e-learning. Okay, in addition to judicial proceeding, court administration and surveillance system, there is another sector that really matters to promote modern judiciary. Yes, that's capacity building for judicial apparatus. Capacity building for judicial official and human resources management is also done through the training and education program that has transformed digitally. E-learning is a long-distance learning method using internet network and digital platform that is conducted and managed by Research and Development Education and Training for Law and Judiciary Agency of Supreme Court of Indonesia. This learning system adopted open source learning management system based on certain reasons, for instance, flexibility. The participants can learn from the anywhere, everywhere, anytime, the module, and join the class anytime, from home or from office, easy to operate, and to improve the new training program. This system has 3 stages of learning methods, such as stage 1, independent learning, is where learners have their own control in learning the provided module on the digital application system. This stage is designed to prepare for step 2 or stage 2, online learning method that conducts more discussion and Q&A session. Of course, still using a digital platform. For some certain training programs, they are still conduct stage 3 or classical class, usually for the certification training that needs simulation or site visit. Online learning system is efficient and effective indeed, mostly in pandemic era. Okay, next slide. Code of conduct. Back to 2014, as the launching of e-learning, first program of this learning system was Judges Code of Conduct. Now, in every training program, Code of Conduct of judges or Code of Ethic of other court official is a compulsory subject, even conducted in the first day of any judicial technical training certification. It demonstrates that Indonesian Supreme Court strives to strengthen the judicial integrity in every aspect, including human resources of judiciary. For criminal case procedure, recently the Supreme Court of Indonesia developed electronic integrated criminal case files. The notion of this digital application is to provide fair, transparent, and accountable services in pre-trial process. For beginning, the system has been employed in 7 courts as the pilot project. Here also the system that are developed in collaboration with other institutions. We can find these 2 digital information systems, for instance, Decision characterization by Judicial Commission of Indonesia is a program based on digital application aiming for public and judges to read the judiciary decision easier with certain indicator, of course, and this application could be downloaded directly from Play Store or iOS using gadget. IT-based criminal processing database system is designed for cases data exchanging between investigator, prosecutor, judge, and penitentiary official. With this integrated system, the case management process will be accessible, accountable, and shareable. The system is also in line with Indonesia One Data policy. So this system supports the Supreme Court duties to give people excellent public services. Ladies and gentlemen, eventually all of those hard work in modernizing Indonesian judiciary result remarkable achievement. Supreme Court of Indonesia achievement have been appreciated by other state bodies in Indonesia. Some of it come from the President of the Republic of Indonesia, the Chairman of People's Consultative Assembly, and the member of the House of Representatives of the Republic of Indonesia. Mainly appreciated for the Supreme Court endeavor to accelerate creation of a modern judiciary and digital transformation in cases management. For transparency and accountability financial report performance, Supreme Court of Indonesia successfully has achieved unqualified opinions from the Audit Board of the Republic of Indonesia for 7 times in 7 years in a row. It's remarkable recognizing from an audit institution. In addition, last week, Indonesian Supreme Court achieved award in innovative program category from a news channel, merdeka.com, for Supreme Court innovation in public services. Yes, here we are, ladies and gentlemen, at the end part of the presentation. In conclusion, implementation of reliable technology in courts encourage transparency and accessibility of justice. Digital system is an instrument in promoting bureaucracy simplified as a part of bureaucracy reform to reduce opportunity to corruption and at last for achieving public confidence. Comprehensively transformation at all levels and sectors, technical, judicial, administrative, and official capacity building will lead to legal certainty and deliver justice. If it eventually all the system, the advanced program and the transformation measures based on digital information technology are designed to promote modern judiciary in improving integrity, efficiency, and inclusiveness as well. Ladies and gentlemen, let's together make sure that we are equipping our judiciary with valuable digital improvement within respect human rights principle. Thank you for your attention. I look forward to hearing comments or questions from all of you. So I give back this forum to the moderator. Thank you.
Thank you very much. Let me moderate further in Thai, and Judge Maria, you can use English channel in the Zoom, no? Interpretation in English, so you will know, can hear the question in English. Translator will be translate from Thai to English. ครับสวัสดีทุกท่านนะครับก็เมื่อกี้นี่เป็นประสบการณ์ของประเทศอินโดนีเซียนะครับว่า อินโดนีเซียดำเนินการเช่นใดในเรื่อง Digital Transformation ก็เป็นอีกรูปแบบหนึ่งที่เราจะได้เห็นความหลากหลายนะครับจากอินเดียเมื่อเช้าแล้วก็มาเลเซียแล้วก็อินโดนีเซียท่านไหนมีคำถามสามารถได้ทั้งแชทบ็อกซ์นะครับตรงที่ผมหรือว่าในส่วนกลางหรือว่าถามโดยตรงได้เลยนะครับสามารถเปิดไมค์ถามได้เลยครับถ้ายังไม่มีแชทบ็อกซ์ถามผมนะครับก่อนหน้านี้ก่อนที่จะมีการนำเสนอว่าประเทศอินโดนีเซียเป็นประเทศที่มีหมู่เกาะเยอะมากนั่นหมายความว่าก็มีผู้คนกระจายอยู่หลากหลายในแต่ละเกาะซึ่งเป็นเรื่องท้าทายที่จะทำให้เกิดการเข้าถึงกระบวนการยุติธรรมโดยเฉพาะเรื่องศาลอยากสอบถามว่าแล้ว Digital Transformation ของอินโดนีเซียเนี่ยสามารถช่วยในการเข้าถึงกระบวนการนี้ได้อย่างไรหรือมีกระบวนการวิธีการอื่นซึ่งอินโดนีเซียใช้เพื่อให้เข้าถึงกลุ่มคนที่อยู่ห่างไกลให้เข้าถึงกระบวนการยุติธรรมได้
Yes, thank you. I really appreciated you raising that question. That's important topic. Of course, using digital system really depends on internet network. Here in Indonesia, not all area covered by internet network. In some area, in particularly remote area, have limited internet connection. So the data states that there are still approximately 12,000 villages not yet covered by internet network. In fact, there is one of the major problems in using digital system effectively, including in judiciary sector. It's an obstacle, of course, to speed up the process of electronic courts. The other problem in promoting digital system in judiciary proceeding is a digital literacy. The lack of digital knowledge surely affect to fully understand the information about judicial process. For the first time implementation, yes, the most challenging part in the first time to run the system is dealing with technical issue related to internet connection, digital literate, and infrastructure. And that's the most challenging part. Another challenging part is acceleration, the competence of the judges and the staff to literate the digital system. That's the training and education agency are for, of course, to train and assist the judicial apparatus. In addition, the continually socialization is needed. That's all. I hope that answer your question. Thank you.
มีคำถามครับโอเคมีคำถามในแชทบ็อกซ์นะครับ On your opinion, by transparency process, online, electronic, and human right, which kind of case should not apply online course?
Okay, that's a good question and important issues. For transparency, we consider the safety matters, of course, and honestly, now we are not yet fully implemented online court. For some part of trial, the examination still conduct in courtroom. For instance, evidence verification procedure, the parties of and the defendant and the plaintiff must present the evidence in form of physical evidence, document, or digital evidence before the judges in courtroom. The procedure aims to ensure that the evidence had been verified by the judges in the front of the parties. So when we talk about the kind of cases that should not apply online court, that based on the procedure, like the cases related to domestic abuse or sexual abusement and either cases that must close, then not open to public. That's my answer. I hope it answer your question. Thank you.
เรื่อง domestic violence ก็เป็นเรื่องอันนี้น่าจะสอดคล้องกับที่กล่าวถึงของกรณีอินเดียกับมาเลเซียแล้วก็หมายถึงประสบการณ์หลายประเทศที่บอกว่าเกี่ยวกับเรื่องความรุนแรงในครอบครัวหรือว่าความเพราะว่าการสืบคดีถ้าเป็นออนไลน์เนี่ยต้องมั่นใจว่าไม่อยู่ในสถานการณ์ที่ถูกกดดันจากคนรอบข้างเพราะไม่เช่นนั้นแล้วเนี่ยก็อาจจะกลายเป็นแบบบิดเบือนการให้คำได้เพราะเกรงกลัวถึงการใช้ความรุนแรงก็เลยต้องมีอย่างอินเดียใช่ไหมก็มีพูดถึงเรื่องกล้องที่ต้องติดเพื่อเห็นแน่ใจว่ารอบข้างเนี่ยไม่มีใครอยู่ด้านข้างเพื่อให้แน่ใจว่าไม่ได้ถูกกดดันอยู่มีคำถามอื่นไหมครับ
Yes. Foremost, related to the children underage, yeah, it must really consider about the court proceeding. Okay, next question.
มีใครมีคำถามเพิ่มเติมไหมครับณช่วงเวลานี้ครับโอเคมีคำถามมาในแชทบอกว่าเนื่องจากอินโดนีเซียเนี่ยมีความหลากหลายมีภาษาแต่ว่าอาจจะเกิดความหลากหลายของการใช้ภาษาด้วยเนื่องจากอยู่ในเกาะหลายพื้นที่ทางอินโดนีเซียมีวิธีการเช่นไรในการอำนวยความสะดวกเพื่อให้มั่นใจว่าผู้คนเนี่ยที่มีภาษาที่หลากหลายเนี่ยสามารถเข้าถึงกระบวนการทางศาลได้
Yes, thank you for the question. That's our country with diversity in languages and other ethnic or race. Yes, fortunately, in all over Indonesia, the Indonesian has been able to speak Indonesia, and for those who can speak Indonesian fluently, yes, the judicial bodies, the court, provide assistance for help these people with underliterate or digital literate, and we have concern to bring the justice closer to the citizen and to reduce all those obstacles, in particularly for this language capability. Okay, it's the answer.
โอเคมีคำถามเพิ่มเติมไหมครับถ้าสมมุติว่าถ้าเกิดตอนนี้ยังนึกไม่ออกแต่ว่าอาจจะไปสมมุติว่าเรามีโอกาสได้ไปเจอบทความถึงประสบการณ์ต่างๆในอินโดนีเซียที่อาจจะได้เจอในอนาคตนะครับเจออินิเชทีฟใหม่ๆไม่ว่าจะเรื่องดิจิทัลเทคโนโลยีหรือเรื่องอื่นๆด้วยเพราะว่าด้วยความบริบทที่ต่างกันเพราะอินโดนีเซียก็เป็นประเทศใหญ่แล้วก็มีความหลากหลายมีหลายหมู่เกาะใช่ไหมครับก็มีประเด็นที่หลากหลายดังนั้นการเข้าถึงที่แตกต่างกับประเทศอื่นๆถ้าเกิดเจอข่าวสารและอยากรู้ข้อมูลเพิ่มเติมว่ามีการบริหารจัดการเรื่องนั้นยังไงก็สามารถสอบถามผ่าน UNDP ได้นะครับแล้วเดี๋ยว UNDP จะช่วยส่งต่อไปเพื่อสอบถามท่านผู้พิพากษาจากอินโดนีเซียได้ในอนาคตเช่นกันนะครับก็ถ้าเป็นในอนาคตถ้าตอนนี้ยังไม่ได้มีคำถามแล้วก็เมื่อวานมีคนบอกว่าช่วงเช้าเนี่ยพอมีการดำเนินการตรงเวลาแต่ว่าทำให้ท่านเนี่ยบางทีต้องการไปย่อยข้อมูลเพิ่มเติมก็แล้วก็ต้องไปทานข้าวก็จะทำให้แบบ ช่วงบ่ายก็อาจจะแบบไม่เต็มที่ ก็เลยถ้าเกิดตอนนี้ไม่มีคำถามแล้วก็เราได้เรียนรู้จากท่านผู้พิพากษาจากอินโดนีเซียได้ครบถ้วนผมว่าเราก็อาจจะสามารถที่จะปิดเซสชันนี้ได้เร็วกว่ากำหนดได้เช่นกันนะครับถ้าไม่มีคำถามJudge Maria, do you mind if we close this session earlier than expect? So participant, participant can also have more time for lunch as well because yesterday we have short lunch and become some issue as well for afternoon session. So is that okay for you?
Okay, it's okay. It's okay. But from before the closing, I would like to thank again for your great enthusiasm, and hopefully my presentation sharing about Indonesian judiciary in promoting modern judiciary could give new insights and experiences for all of you. Stay safe, stay healthy, and have a fruitful day, everyone. Thank you.
Thank you, Kap. Let me thank you again on behalf of participants for this presentation, and hope we can sharing exchange of knowledge in the future as well with judge from Thailand and also other country in ASEAN and also other and beyond as well. Thank you so much, Judge Maria. Thank you.